And welcome back. Former SARS Commissioner Tom Moyane will never get to cross-examine Public Enterprises Minister Pravin Gordhan. That's after Commission Chair Raymond Zondo dismissed his application. Moyane's advocate Dali Mpofu was keen to challenge Gordhan's testimony from last year, in which the Public Enterprises Minister detailed the enmity that arose between him and the former tax boss. Let's take a look.
Deputy Minister Jonas and I paid a visit to Mr. Moyane. Of course, he makes a big thing about me not shaking hands with him. But that's why I say I have no relationship, because I thought he was rude to me. When the first of the Sunday Times reports were coming out, I actually phoned him because Minister Nene was in the US for a meeting of the IMF. He didn't return my call, and that's normal protocol, is that even if another minister is calling you, you have the courtesy of returning the call. But anyway, those 10 issues, part of the 10 issues is substantial changes to the operating model of SARS.
So Zondo said the test for cross-examination is whether it is necessary and relevant to the Commission's work. We're joined now by legal analyst Ziyanda Nyanda, who is an associate at Mncedisi, Ndlovu and Sedumedi Attorneys. Now, given the criteria outlined by the Justice on the Commission's rules for cross-examination, do you think that Moyane's legal counsel or his client had a different interpretation?
Good evening, Tabiso. What I can say is that we must first look at these criteria. One, it must be in the best interest of the inquiry to receive that application for cross-examination. Two, it must be necessary, as you stated beforehand. And three, if you're an implicated person, you must state the manner in which you're implicated and state your version of events up front. And your question was whether or not the legal team of Mr. Moyane actually misinterpreted.
Or would have had a different interpretation, because Justice Zondo said, if you look at Rules 3.3 and 3.4, he says there was no direct reference to, if I'm using the right legal terminology, referring to Tom Moyane, and that there was no statement made by Pravin Gordhan which implicated him in his statement that would require a direct rebuttal from Tom Moyane, if I am understanding it correctly.
You are understanding it correctly, Tabiso, but as I mentioned beforehand, we must firstly look at the rules, and that if you're furnished with a statement as an implicated person, you have every right to look at that statement and state in your version of events.
So you would have had prior knowledge, that's what you're saying.
You would have had prior knowledge, and you would know at that point in time whether or not you are implicated, And Chief Justice Zondo went to great lengths to say that it's up to you as a person who receives that statement. It's to decide whether or not you are implicated or whether or not you are not implicated. And in that light, they decided that they were implicated by that statement.
So he was well within his rights to ask for a cross-examination. And one of the things that his legal team was saying is that the language used to describe Tom Moyane was that of a racial nature, as Dali Mpofu said. And he felt that on the grounds of that, or in fact he said that Pravin Gordhan claimed in an affidavit that he was a boy that would have a racial tone to it. But my question is, would you say on that basis there is public interest in that cross-examination occurring then?
There may be public interest, but will it assist the Commission? That is the first question.
That is the bottom line.
Will it assist the Commission? And secondly, on the statement that on Mr. Pravin Gordhan's statement, we need to analyze whether or not he is putting his version of events with regards to those statements made, and not, let me say, making blanket statements, or not specifically rebutting or stating his version with respect to a particular statement that was made by Minister Gordhan.
So let's just also look at the genesis of this case and how it ended up here. Tom Moyane and his legal team say that they see a connection to state capture. They believe state capture, and that's why they wanted the cross-examination. But he had a hard time with the North Gauteng High Court. It was very critical of Moyane and his legal team in the manner in which they comported themselves, as it said. And they also failed to convince the North Gauteng High Court to reject various applications. One of them being to completely do away with recommendations of the Nugent Commission, actually not even recognizing it. Do you think that would colour what would be before a case such as this inquiry? It's a judicial commission of inquiry, so would they have had to look at legal precedent in terms of the genesis of the case?
I think the first thing that we need to look at is Mr. Moyane's rights to exhaust all legal remedies. So if the Nugent Commission makes a recommendation that he feels is adverse or affects his interest in a certain manner, he can take that recommendation on review. He can take it up to the highest court in the land, and he has every right to do so. And his legal counsel have every right to do that until they reach the highest court in the land. So with respect to the Nugent Commission, we can't criticize the conduct of his attorneys. Well, I can't in my personal capacity, because he has that right. He has that right to go to every single step and review the decision of the Nugent Commission if he feels that those decisions were, say, irrational, unlawful,
so let's talk about whether or not there is legal basis. And I want you to take us through that from the perspective as us viewers, laymen, who would not understand it in that way. Basically, we're saying, was there a case to be made? So before the North Gauteng High Commission, the North Gauteng Commission court driver, one of the things that he wanted was that not only to prevent the president from appointing a new SARS commissioner, but also preventing his own dismissal. So on the basis of what it had to look at and the legal arguments that were put before it, was there a legal basis?
There is a legal basis if he is relying on irrationality, or if he's relying on unlawfulness, or if he's relying on various certain grounds that are set out in the Promotion of Administrative Justice Act. So there are various grounds for review that you have to set out in your application that you bring to court. So to review the decision, the recommendations of the Nugent Commission, he can set out those grounds, and if those grounds are successful, if he can prove those grounds, then he's in every right to do so. If he can prove those grounds and the court finds that he has proven a ground of, say, for example, illegality, then that's the finding.
Mm-hmm. So one of the things that he also was trying to prove, that he was treated unfairly, not only in the facts that he presented before the Nugent Commission, he also wanted Judge Nugent himself to recuse himself on the basis of what he perceived as bias. Bringing it back again to state capture, he still believes that he has been unfairly treated. And I'm just trying to look at other legal recourse, legal avenues, because there may be some people's interpretation following the decision by Judge Zondo that this is it, this is the end of the road for Tom Moyane and his legal team.
Well, I think if we look back at the reasons that he approached the court, and the reasons he raised in argument before Judge Nugent, he raised the issue of double jeopardy. So why am I, during a disciplinary inquiry, also being subjected to the same sort of investigations in the commission itself? And he then raised that issue of double jeopardy. And the issue, one must actually state up front that there is no nothing in the rules that precludes a disciplinary inquiry from happening on the one side and a commission of inquiry from happening on the other side. They serve two different purposes. And so you can be within a disciplinary inquiry that's investigating your conduct, and you can be in the Nugent Commission of Inquiry that is investigating the very same conduct. They serve very different purposes. So in his legal arguments, yes, he's been through all the legal steps, and he's come here, and there's this application that's been dismissed, let me say. He still does have
legal recourse. Where else?
He has legal recourse within the specific rules of the Zondo Commission of Inquiry, which state that an implicated person can actually apply to the Commission to make oral or written submissions with regards to the conclusions or the findings made by the chairperson of the Commission. So he has legal recourse in that respect. And then even after the findings of Deputy Chief Justice Zondo, he still has legal recourse in the sense that he can take the decision on review in the High Court. And
I mean, some would say to what end though, and obviously it's not necessarily up to you to answer that, but for people sitting at home watching or listening or having seen the proceedings, they say to what end? You're surely not going to get your job back. Is it the more important aspect of this clearing up your name? Because while there were many other things that came out of the Newton Commission, mismanagement, etc., the rogue unit at SARS was center stage, you know, in terms of limelight carrying or, you know, headline creating stories. And this is something that he's drawing to the Commission to say you cannot ignore this aspect of it because it is a large part of the state capture, and that would also involve SARS. Is there an opportunity at some stage that he may be able to revive this application to cross-examine Pravin Gordhan under the guise or argument that this is important information that is relevant to this commission?
As I just mentioned previously, he can make an application to the commission itself, and on the conclusions drawn today, which is the application for cross-examination is dismissed, he can make an application, and in that application he can then set forth his grounds or his grievances with regards to the conclusions that were reached by Deputy Chief Justice Zondo in dismissing his application. So he can still state those grounds and why he feels aggrieved by that decision. So it's a form of internal appeal procedure that's provided for within the rules.
So perhaps let me just, as a final question, the whole criticism that was offered by the North Gauteng High Court in terms of the conduct of the legal team or Tom Moyane. In self-defense, is there such a thing as comporting yourself in a bad manner? If ultimately your goal is to clear your name, wouldn't you use every legal avenue, every trick up your sleeve, every trump card to try and clear your name or get the desired outcome?
As an attorney, advising my client, that is what I'd advise him to do, to use all legal processes available. Despite the criticism out there, that is what I'd advise. You must use the internal procedures afforded to you by the Commission in order to clear your name. You must use the review procedures provided for in our acts, and also just use the Constitution. You have every right to approach the court, and you have every right to make sure that you exhaust all your legal processes, and there's nothing that stops Tom Moyane from doing that. Perhaps
just as a general comment to finish off, as a legal person, what would you say South Africa has learned through these processes at the State Capture Commission, not only in terms of our own individual rights, but as a country, the criminal justice system that has been so heavily criticized?
I think for the first time we've seen a commission that's taken accountability very seriously. So even before the commission is concluded, we've got a directorate that's established by the National Director of Public Prosecutors. We know for a fact that they are going to try and use the evidence that's coming out of the commission to prosecute individuals that are implicated or that are found to have committed certain acts of corruption. So I think what we've learned is that commissions of inquiry are no longer just a fact-finding mission where recommendations are made to a president and they're non-binding. We've learned that this commission and its sittings are very important, and people are going to be held accountable, and the purpose and purport of this whole commission is to find the truth. And
And I think that's a good note to leave it on. Thank you very much, legal analyst Ziyanda Nyanda, associate at Mncedisi, Ndlovu and Sedumedi attorneys.